two primary factors that led to the issuance of a number of board decisions overturning precedents during December 2017. First and foremost was the fact that Chairman Phil Miscimarra's term was expiring on December 16th, coupled with the fact that the president had not yet nominated a replacement for Chairman Miscimarra. I think one of the most significant decisions to be overturned was Browning Ferris. In Highbrand, the board essentially rejected the Browning Ferris test for determining joint employer status, and it reverted to a more common law standard as the board had followed for many years before Browning Ferris was decided. Browning Ferris said that the board would could find joint employer status based on an employer's possession of the ability or the right to control or affect terms and conditions of another employer's employees directly or indirectly, and that it would find joint employer status if that right to control directly or indirectly was possessed, even if it was not exercised. In Highbrand, the board has said that it is going to look, as it did previously, at direct and immediate control and whether it is exercised and not just whether it's possessed. So that's a very big change. The board members, Kaplan and Emanuel, have given some indications in several footnotes and decisions that said where they've said they want to look at particular issues and they think that they should be ripe for reconsideration by the board. These include the precedents from the Obama board concerning confidentiality in settlement agreements. The Obama board held that in many circumstances requiring confidentiality as to the terms of a settlement agreement unlawfully interfered with employees' Section 7 rights because they couldn't tell the terms of their agreements to coworkers, they couldn't share them, their coworkers couldn't learn of them. Something else that came out in December was a request for information from the board looking for comment and experience from parties across the spectrum on the board's 2014 amendments to the representation election processes. Those amendments are commonly called the ambush or expedited election rules. They resulted in not only much faster elections, but also changed the structure so that parties, employers and unions, really lost the ability to litigate certain issues before an election took place that were significant. I think it's likely that that's a precursor to another round of rulemaking by the board to address some of the inequities in those 2014 election rules, if not to revert to the prior rules completely.